Welcome to the After On podcast. I'm Rob Reed.
And I'm Tom Merritt. And this is a special episode designed around the book After On.
Each of these special episodes focuses on one aspect of the science, tech, and social issues explored in the novel. Now, you don't have to read After On in order to learn from or enjoy these podcasts.
That's because we wait until the very end to discuss the book in detail and to really tie it to this week's topic.
That last section will make perfect sense if you're reading the novel. But if you're not reading it, just tune out at that point. You can always come back if you decide to read it later.
And we'll warn you before we get to that part. But first, we have a lot of things to talk about, which should be interesting to everybody. Specifically, privacy. In the book, Flutter and other companies are skating on the edge, and maybe over the edge, of the line between respecting and violating digital privacy. And that is a line that lots of real-life companies skate around on, over, and just back and forth on today. Who better to talk about what's going on with digital privacy than Cindy Cohn, head of the Electronic Frontier Foundation?
Yes, and Cindy has been on the front lines of the fight for digital privacy since the 90s, when fighting for digital privacy was so new, there weren't enough lawyers to do it. So let's talk to her about that and what's happening to your privacy rights online. Thank you for sitting down with me, Cindy.
Oh, thank you.
Here in your beautiful sun-drenched San Francisco offices, I'd like to start by reading what I believe is a newish tagline from your website, which is the leading nonprofit defending digital privacy, free speech, and innovation. That feels like a pretty bullseye and succinct description of EFF.
And that is true. I think we are the oldest and the biggest organization devoted to people's rights online. And what I like to say is when you go online, we make sure that your rights go with you.
And one thing that has amazed me is just the range of what you guys do. I mean, you're advocating, you're filing dozens of amicus briefs per year. You're presenting your case at the Supreme Court, 8 times this session alone between arguments and briefs. You're promoting and supporting new laws. Sometimes you're writing them. You're creating software and services that are used by millions of people. It's an extraordinary range. But before we talk about that, I'd like to briefly just discuss your own background. I know from a prior conversation that there were elements of your childhood that you felt made you particularly excited and welcoming to the World Wide Web when it arose. Would you care to talk about that for a moment?
Sure. You know, I grew up in a very small town in the middle of Iowa. It's Newton, Iowa. And it was a great place to grow up. You know, people didn't lock their doors and there were bicycles, but it had a little teeny library and wonderful teachers and wonderful schools, but limited resources. And I read my way right through that library. And when I heard about this idea of a digital network that would have access to all sorts of information, I felt like that little girl again, only she wasn't limited by the size of the Newton Public Library anymore. She could find out anything she wanted to find out, and the world would open in a way that just wasn't available when I was a kid.
Not to minimize the many years of personal development and hard work that connected your childhood with the beginning of your work with EFF, is it fair to say that you followed a fairly linear path through school, through college, through law school, ultimately leading to a career in a San Francisco law firm?
Pretty much. I did, after law school, I went and I worked at the United Nations in Geneva I had a year fellowship on that. I worked in human rights, the Center for Human Rights in Geneva for a year. And because I was interested in international human rights, I was interested in how to make the world a better place. And then when that ended, I came to San Francisco, one of the many people who come to this city and fall in love with it and never want to leave.
Which is why the rents are so high.
It is why the rents are so high. And started a legal practice and somewhat randomly met some people who were involved in the internet before there was a World Wide Web in about 1990.
EFF itself, it's perhaps appropriate that it rose up online at a time when virtually nobody was online, and certainly very, very few organizations were emerging from the primordial soup of the pre-World Wide Web internet, but there it was. It came up on the well, right?
Correct.
It was John Perry Barlow, correct?
It was John Perry Barlow and Mitch Kapor who really had the idea together after some Secret Service raids on some bulletin board systems. The Secret Service had a thing called Operation Sun Devil, which ended up being some raids on some small businesses and people's houses, claiming that some internal AT&T documents had been stolen. The documents ended up not being particularly important anyway. The Secret Service went all out of control with these raids and basically took anything that was plugged into the wall. And there were, I think John Perry Barlow and Mitch were kind of aghast that they felt like they needed to start an organization to defend, basically the free internet. And the story that they tell is that originally they thought it would be a foundation, as in a foundation that gave grants to lawyers to defend people who had been on the backside of some of these raids. They discovered that there weren't any lawyers who understood the technology well enough to really step up and do the defense. And so EFF started hiring its own lawyers to do this kind of work.
And you met these folks almost immediately after they started it, correct?
Yeah, I certainly did. I met John Gilmore. So Mitch and John Perry Barlow really had the original idea. Very quickly, John Gilmore became involved, and he's really credited as being the third founder of EFF.
It was almost a 10-year path from your first acquaintanceship with these folks to when you came on full-time, correct?
Correct. In about 1993, John called me and asked me if I would take on a lawsuit that they wanted to put together at EFF involving, of all things, encryption technology, which at that point in time was regulated by the U.S. government. You couldn't export it without a license. And the government defines export as publishing to the internet. So John asked me if I wanted to take on this case. And I said, well, what does this technology do? Does it blow things up? And John said, no, it keeps things secret. And I said, well, that sounds like a First Amendment problem to me. And he said, me too. Will you take the case? And I did that case with the EFF as an outside lawyer from about 1993 till 2000. And in 2000, they asked me to come and join full time.
And you became the executive director a couple of years ago, correct?
Yes, I was the legal director from 2000 to 2015. And then in 2015, my boss, Sherry Steele, moved to Seattle and abandoned us.
Oh, my goodness.
And they asked me to take over as executive director.
How many folks is it now? It's about 75, right?
It's about 75, yeah. We have about 20 lawyers. We have about 10 technologists who are building technologies.
Yep.
We have about 10 activists who do things like, the Write Your Congressman kinds of things that we do, and the tweeting and the blogging. We have about a 6-person international team. And then the rest is, support, whether that's the fundraising team, the finance team, the people who pay the bills and things like that.
Speaking of paying the bills, you're admirably transparent with the public about your finances. Looking at your most recent annual report online, you spent about $9.5 million in 2015, and you took in about 2/3 of that amount in the form of small donations from about 35,000 members, I think you told me in a prior conversation. Then you more than covered the remaining amount. In fact, you had a surplus of about $7 million, which equates to net margins that most private companies would be very proud of. And this surplus came from an impressively wide variety of sources. There's money from large donors, there's foundation money, a smidgen of corporate money, and then there was a line item I had not previously seen, and it's...
Cypre.
Is it French?
It's Old French, yes,
it's Old French. And tell us what that means, because that is an unusual category, and it's a very powerful one, I think, for you guys.
Yeah, Cypre is Old French. It means the next best. And Cypre is what happens at the end of a lawsuit if there is money left over. Let's say a defendant, this happens in privacy cases a lot, which is why EFF has a prominent role in a lot of these cases. Let's say a company is doing something that violates people's privacy. An example from the last couple of years is Facebook sponsored stories. So Facebook was using people's faces in its advertising as if they were endorsing products. And people were not endorsing products. Facebook was just really misusing this. People sued on behalf of this. And a settlement was reached, and the settlement let people whose faces were misused apply for a little bit of money back. Not a lot. It's hard to put a dollar value on this, but a little bit of money back. Some people applied, but not as many as there was in the pool.
Right.
So then they've got this pool of money left at the end of a lawsuit where the people who, wanted compensation got compensation. There's money back. Nobody wants it to go back to Facebook. Facebook should still be punished. They shouldn't get the benefit of the fact that people didn't apply.
And nobody wants it to all go to the lawyers who brought the class action suit and are the only people really making real money from this.
Exactly.
Yeah.
And so Cypre is a thing that courts have created, and it's actually old. It's an old thing to try to make sure that the money goes to something that is the next best.
And that's consistent with the values or the ideology, if that word applies, of the case.
That's right. Something consistent with the issues that are going on in the case.
And is it the judge that makes that determination?
Ultimately, the parties will usually propose who receives it.
Those who were sued or those who were suing, or both?
Both. Traditionally, it's just the plaintiff. In the last couple of years, the defendants have also participated in the process much more actively. Many people are nervous about that. I'm one of them. I don't know that the bad guy should be able to direct where the money goes.
Right.
But ultimately, they present a slate to the court, and the court decides whether this is the right slate. But often the first time we even hear that we're in the pool is when the papers are filed for final approval. It's really good, and it supports a lot of organizations that people rely on in privacy and other areas as well. Consumer cases often have this kind of cypre thing. EFF gets this money, ACLU gets this money, our friends at Epic gets this money sometimes, the Berkman Center.
And is it all class action suits have this?
Yeah, lots and lots of cases have it. It's not every case, but it's a well-used tool for lawyers and judges to use when they've got this kind of situation. And it happens a lot in privacy cases because it's hard to figure out what the right compensation is for a privacy harm sometimes. And they often affect a whole lot of people.
Oh, yeah, huge numbers. I just actually got a notification. I used Anthem Insurance, and I think that there's 80 million people whose records were in some degree put out to whatever hacker got in. And I think the settlement amount is something north of $100 million. So it's like, I don't think I'm going to rouse myself to collect my $1.16.
Correct.
And whenever I got those notifications, it would kind of make me grumpy because I figured somewhere there's a lawyer making a fortune and nothing is actually going to the folks who suffered. But this is really interesting. I had not been aware of this mechanism until I read your annual report. Now, to go back to your wonderful tagline, the leading nonprofit defending privacy, free speech, and innovation, I thought maybe we talk through an example of each of those three things, privacy, free speech, and innovation, just to get a flavor of what you do, because with the 75 of you being as busy as you are, there's no way we could cover the full range of your activities. Starting with privacy, there's a privacy case that has chilled me for many years, and I hadn't realized you guys were involved in it, but as I did my research, I was unsurprised. This is the matter of Cisco and China. I'd love it if you could tell us briefly what went on there and how you guys have been involved in pushing that case forward.
Well, this is a case where we have participated as amicus curiae, so we don't represent the parties, but we have been tracking it from the very beginning.
And filing briefs and so forth.
Yep, we filed briefs in the district court and the Court of Appeals as well, and we're waiting for the Court of Appeals decision. The case was just argued in the Court of Appeals about a month and a half ago. So, but this is a case against Cisco brought by members of the Falun Gong, which is a religious minority in China that the Chinese really don't like.
And a largish one, tens of millions of people, correct?
Yes. Yeah. It's quite a large minority. It's kind of a meditation focus.
It's very peaceful is my feeling from it from a great distance.
That's correct. And the Chinese do not like the Falun Gong, and the U.S. State Department and Human Rights Watch and human rights groups all around the world have well-documented dossiers of torture, disappearances, violence against these people. And it's very well documented for many, many years that the Falun Gong are a targeted minority by the Chinese for very, very serious human rights abuses. So along comes the Great Firewall of China, which is the protection that the Chinese internet, there's a set of computers that stand between the internal Chinese networks and the rest of the internet. Lots of countries have this kind of firewall idea, but it was really pioneered by the Chinese in order to limit what information their people had access to.
And they have a tremendously sophisticated one as well.
That's right.
Because there's so much cyber sophistication in China and in the Chinese government in general.
That's right. And in fact, the Great Firewall was originally built by Cisco for China, but I think at this point...
You were kidding. No. Cisco built it for them, like a services group or something like that?
Correct. Cisco was the original big contractor for the Great Firewall of China.
I hadn't realized that.
At this point, the Chinese have pretty much taken it over because they've been able to absorb the technology. But certainly when it was built and for the first chunk of time.
Cisco built it for them.
Correct.
Hi, Cisco. We want to censor the internet for 1 billion people. Hey, we're in.
We're in. It was a gigantic contract. And that in and of itself is troubling, as you pointed out.
I feel terribly ignorant for not having known that.
But even worse, Cisco built for the Chinese. One of the things that a firewall can do, it not only limits what comes in, it can track what comes in and help track people. It's a surveillance mechanism for people inside China, as well as a censorship mechanism. And Cisco, we have internal Cisco PowerPoints that brag about how they built a surveillance system that is the best system available to help the Chinese government identify Falun Gong.
Now, this part I did know about it. It's basically a Falun Gong module.
Correct.
Yeah. And that is just chilling.
And that's what the case is about. The case is about custom building something to help identify a targeted minority for oppression. And
who are going to be tortured and in some cases, I'm sure, executed as well. There have been a lot of executions among Falun Gong as well, I believe. Yeah.
That's right. And so, our argument in general, we are for innovation. We think people should be able to build tools, that the tool maker should not be responsible for people who misuse the tools. As a general rule, if you build a widget and you build a hammer and somebody goes out and takes a hammer and knocks somebody over the head with it, you're not responsible. The hammer builder is not. This is very different.
Yeah.
And this was built on spec to target a particular group that China has a well-known history. Cisco is not naive here, a well-known history of engaging in gross human rights violations against. And including, there's bragging about how we can not only help you identify the Falun Gong, we can help you put a dossier together so when you've got this person under interrogation, if you threaten their wife, they're likely to turn over. Yes, interrogation dossiers that they can then use to make sure that they...
With the Cisco logo on them.
The PowerPoint slides certainly have the Cisco logo on them.
Yeah, that's what I mean. That is...
And so, we think that's over the line and that at least it's worthy of more investigation. Cisco claims that they didn't know, that they're not responsible, all those other things. I think that that's not true. But all we're asking the courts to do is to say, you need to look more deeply into this. You need to make Cisco come clean about how much they knew and how much they were involved in building a tool of repression.
Now, who is the you that the court is addressing in that case? So you're asking the court to tell some investigative body to look at it more carefully, or to tell a lower court to look at it more carefully?
Right now we're asking the Ninth Circuit Court of Appeals to send the court case back to the district court, and the district court ought to open it up and let the plaintiffs ask questions of Cisco that Cisco has to answer.
Got it. So the district court had been easy on Cisco, and it's up to the Ninth Circuit to say enough, Mr. Nice Guy.
Yes.
Let the plaintiffs get in there.
Correct.
That is a chilling case, and it goes back. I feel like it goes back about 5 years when I first started hearing about it.
Yes, it's been a long time. The district court judge sat on the case for a very long time, but then ruled that the case should be dismissed and it shouldn't go against Cisco. And then the Ninth Circuit appeal took quite a while as well. I think it's a troubling case for the court because they're nervous about looking like they're meddling in the foreign affairs of another
I guess
country.
there's a jurisdiction issue.
But I think that when we live in this world, first of all, Cisco's a U.S. company, and they do a lot of this consulting from the U.S. This is where especially at the time that they built this, the engineers who designed this stuff, the people who really designed and developed this code were in the United States. So, we have a responsibility. You have a responsibility as an American to follow American law, even if what you're building is going to be used by somebody overseas. And so we think that the human rights claims here are strong and they're worthy of going forward. So we'll see.
That is privacy with a capital P. I know that a lot of the privacy work that you do, protects American citizens from things that are quite minor relative to getting tortured. But let's go on to the next thing, free speech. One of the things that I know you guys have fought a great deal is SLAPP cases. Could you define what SLAPP is and then talk about just sort of an exemplary case of SLAPP that you guys have gotten engaged in?
Sure. A SLAPP case, SLAPP stands for Strategic Lawsuit Against Public Participation. So it's got an extra P at the end.
Yes, it is a cool spelling of SLAPP. Yeah.
And the idea is that when you bring a lawsuit, not really because you've been injured, but really because you want to shut somebody up. You want to intimidate them from speaking. And we've had a range of these kinds of cases that we've represented people in, everywhere from people who were shareholders in a company who were on a forum saying, I think that this company is doing the wrong thing, or I think that the leadership needs to be replaced, and somebody brings a SLAPP suit to try to shut them up.
Yeah, and SLAPP is a fascinating field because it basically involves the privatization of speech restrictions. Mm-hmm. And so oftentimes, when I talk about freedom of speech in the United States and so forth, people's eyes, for not unsurprising reasons, might roll a little bit. It's like, well, we might have small issues here, but we're doing pretty well vis-a-vis the rest of the world. But what's so insidious about SLAPP cases is that companies that don't want you criticizing their products, or, even questioning, or individuals who don't want you questioning exotic claims that they may make about their own background, yep, can basically take out these nuisance lawsuits as a way to just signal to people, don't you dare criticize. And the fact that speech restrictions are in effect being privatized by an overly litigious society is really, really chilling to me.
It is a crazy thing. And the way that the SLAPP law works, just to back up a little bit, is if there's a SLAPP law in place, California's, for instance, if you sue somebody and they say, you're just suing me because you don't like what I'm saying, not because you have an actual claim, it shifts the burden back on the person suing,
right,
to have to demonstrate and bring forth at least minimal evidence that there's actually a cause of action here, and this isn't just, I want to shut you up.
Yeah.
And so by flipping it back onto the person suing to have to make their case, or at least a piece of their case early, you wash out those cases,
the frivolous ones
that are about bile. And we've represented people, we've helped people who have been criticizing public officials who found themselves on the backside of these things, as well as, criticizing products and things like that.
One of the most egregious cases that I'm aware of is somebody we both know, Mike Masnick, who runs the website Techdirt, and he also runs a think tank called Copia, argued in a couple of posts that a particular person who claims to have invented email, in Mike's personal opinion, and he presented a great deal of evidence in these posts supporting his opinion, Mike stated that in his opinion, this guy did not invent email. Mm-hmm. And he is now being sued for a crushing amount of money, I believe, for a tiny business like his own. He's got fewer than 10 employees. And merely for stating his opinion, I don't think this guy invented email as he claims, and here's my evidence.
Yeah, it's a horrible case, hitting on two of EFF's issues, of course, people claiming to have intellectual property rights in stuff that they did not develop. So the underlying thing about who developed email falls into a patent fight, but also then going after somebody like Techdirt, who's covering the story
in a journalistic form,
covering it, presenting the evidence, and presenting his conclusion. It is very chilling, and we're seeing more of this. The Gawker case is one that most people have heard of, but this is happening. It happened to Mother Jones recently. Now it's happening to Techdirt. This is a strategy that powerful people are using to try to silence press and coverage of the shady things that they're doing. But it's not just the press. It's ordinary people are finding themselves on the backside of these kinds of claims as well. So it's very chilling. And one of the things that, is worrisome about this is that the legal system, while there is insurance that can help you with your legal fees, it doesn't compensate you for the time you have to spend on this. And one of the things that Mike has said, and I've watched this with my other clients as well, is that even if you've got good lawyers, it can drain you if you're trying to run a business and defend yourself in one of these cases.
Yeah, he gave a recent talk at NYU, and I think he said that the number of articles that the site is now posting has dropped by about a third.
Yes.
And that's devastating for your income. And, Techdirt is a really, really important and incredibly well-researched voice on a lot of important issues.
Yep.
And niche issues, issues that are not covered by dozens of publications. And the fact that they're falling silent because they have to defend themselves against somebody who just really wants to shut them up is pretty grim.
And it's important not just for Mike, which of course we care very much about Techdirt. It's important to all the rest of us.
Yes.
Remember, the First Amendment goes both ways. It's not just your right to speak.
It's your right to hear.
It's your right to hear as well.
Yeah.
And so I think all of us ought to look as ourselves in these cases as having a stake in what happens, because the information available to us is going to be reduced if these people get silenced.
So the last thing in your tagline, innovation, I would love to talk about patent trolling, because that's an issue that has intrigued me for a long time. I was hit by a patent troll back when I was running my startup way back in the day. And I feature a patent troll in my novel, which is kind of a comedic case, but there are comedic cases in the real world as well.
That's right. And we've taken on so many bad patents. We actually have a stupid patent of the month feature that comes up at EFF. The one that I think was the most fun for us was somebody tried to claim a patent on podcasting. So here we are on a podcast.
Here we are on a podcast. I hope I'm not violating a patent, but perhaps I am.
You are not, because we got it turned back. But for a while, podcasters, ranging from ones you've heard of, like Adam Carolla and Mark Maron's WTF and other things, were starting to receive demand letters from this patent troll called Personal Audio, claiming that they invented podcasting, and so therefore they had to pay up. And it was hitting, clearly big podcasts, small podcasts, but even the biggest podcast is not a gigantic money-making venture. And so this was a tremendous problem for people. And we were happy to pick up the mantle and bring an action in front of the patent office to get this patent scaled back pretty dramatically.
So you led that charge. You got your lawyers on it, you financed it, and away you went with it.
That's right. In fact, we did some crowdfunding for it at one point. This is tying back to SLAP as well. One of the things that the little company did was they tried to subpoena EFF and get us to turn over all of our donor information. So it was a form of a slap there.
All of your donor information.
Yeah, all the donor information that might have gone to the podcasting thing. So we actually were able to fight that back, but we actually went to the community and said, would you help us? We need to fight this thing. And the support was overwhelming. We raised way more money than our goal had been on that. But these things sometimes feed one into the other. But the podcasting patent, people have claimed patents in all sorts of crazy things. There's a whole series of patents that are really just, I did this thing with a computer.
Right. Or I thought of this thing.
Yeah.
Sometimes it's like, I didn't do it, but I thought of it first. And I think folks, until they've been through the ringer with one of these things, don't realize what a profoundly chilling effect it has on innovation.
Yep.
And I've talked to lots of entrepreneurs who kind of went through a couple of times, they've started a couple of companies and are thinking about starting their second or third or fourth. And many is the time that I hear people saying, you know what, I am just so sick of these patent trolls. And every company I've started, it has just inhaled countless millions of dollars and hundreds of hours of my life. And you know what? I'm not going to create those jobs. I'm just not going to do it again.
Yep.
Now, people have many reasons for not starting their umpteenth company, but that is one that comes up a ton.
Yep.
And it is definitely, I don't know what the companies are. I don't know what the products are. I don't know what the jobs are, but I can absolutely say with certainty that many companies and products and jobs do not exist because of this pernicious effect. Now, it seems that your biggest actions generally end up in court appearances or pleadings to court or documents to court. Mm-hmm. You've got lawsuits, Freedom of Information Acts. You defend people who need it, the amicus briefs, appearing before the Supreme Court, et cetera. Many advocacy groups rely much more on lobbying. And I assume you do some lobbying as well. I mean, whenever you're defending new legislation and so forth, that probably falls under the rubric. Why do so many advocacy groups do lobbying rather than court action? Why have you guys chosen this path?
Well, I think that the big thing is that the issues that we are most trying to vindicate have to do with the Constitution. They have to do with the First Amendment, the Fourth Amendment, patent clauses in the Constitution as well. And in the U.S. legal structure, the keepers of constitutional interpretation are the judiciary.
Right. It goes to the judges.
It goes to the judges. And so if you really want to make sure that code is speech, you could go to Congress and try to get a law passed, but ultimately the thing that you want is you want this to be part of the constitutional analysis. And so that's really the right place for us to put our energy, given what we're trying to do. We have three tools: law, technology, and activism.
Right.
Law can involve the lobbying, but again, I think judicially, building technologies that protect you is another huge pillar of what we do. And then the activism, which really is about trying to make sure that people who use the internet are aware of how their rights work and stand up for them when the time comes. That takes us into lobbying a lot. You know, we were part of the group that stopped SOPA and PIPA, for instance, a very bad internet censorship proposal that was put forth by the content industry.
Yep.
We were part of the big push for USA Freedom, which was a law that stopped one of the NSA's big surveillance programs, the mass collection of telephone records.
Yep.
We have a lot to do in that area as well. But believe me, the NSA doesn't like to lose, and they lost something in that fight. So we definitely do the lobbying, but I think that our focus is often much more on the judiciary and on the technology.
And I would like to hit on the technology because to me, that's one of the most intriguing things that you guys do. I was involved in a fair amount of lobbying, really more defensive lobbying than anything else when I was running an online music company. So I got to know a lot of trade associations. I got to know a lot of organizations that participate in, the public discourse. I'd never met one that made as much software as you guys. Maybe we could talk briefly about Privacy Badger.
Sure. What
that is, how you got to 1 million users without a dime. And, we'll use that as an example of software that you developed to get into lots of hands to promote, your agenda.
Privacy Badger is a good example because it grew out of some policy fights. So in the last few years, I think everybody's been aware that a lot of what you do online is tracked by the NSA. That's a whole other fight, but it's also tracked by commercial entities who want to serve you better ads or basically understand you better in order to extract more money from you in various different ways. But the internet doesn't have to be built that way. And there was a proposal that came in part out of us, but largely out of Stanford, for a do not track option on your browser where you could communicate to whatever website you're visiting. Look, I don't want to be tracked.
Akin to the do not call flags that many of us have on our phone number. Those who still have landlines, my landline's long gone, but.
Yeah, exactly. The same idea to really let you have a voice in this because, I would go to these conferences and you'd have all these advertising people going, people love the advertising. It's so great. They know when you want shoes. And then I'd talk to ordinary people who would be like, that's creepy.
Right.
And so the idea of the do not track was to let you have a voice in this conversation. Well, we were involved in some multi-industry talking groups about how to develop a do not track standard. And one of the things that the members of the industry kept saying was that it was really too hard. It was complicated. You couldn't do this thing, that the best we could do wasn't not tracking people, but don't tell people you track them. So we'll track them just as much, but we don't let them know that they're being tracked. And our technologists came back from one of these big multi-stakeholder meetings and were furious. It's not that hard. It's easy to build one of these things. You could build something that implements a real do not track policy instead of these phony do not track policies that these people are developing. We could do it. We could write it in a weekend or whatever they said. And we decided, let's do this. Let's write
take
a
real weekend.
It was ended up being a lot more than a weekend.
It usually does, yeah.
But I don't know that they even said a weekend, but they said, look, this isn't that hard. They're overly complicating it. It can be very simple to block something that at least blocks third-party cookies on websites. And so they built Privacy Badger, and it's a plugin for Firefox and Chrome, the open stores. Apple doesn't have an open store. And you can plug them in, and they will block third-party cookies. And the companies who want relief from this blocking follow a very strict do not track set of obligations. And if you follow real do not track, not fake do not track, then Privacy Badger will load properly and not block your cookies. If you promise what you're going to do with them is only things that are legitimate and easy to see.
And you've got 1 million users now, right?
We have 1 million users as you mentioned, without a drop of advertising other than telling the world on our website that we have it, because people really want this. But it's not designed to be a commercial product. It's designed to demonstrate that
this can be done.
Yeah. And now, there are other companies who are starting to sniff around and ask us if they can. It's open source. People want to, take the code base and do something with it. They certainly can. But the idea was to use our technical chops to try to blow a hole in some of the...
And maybe you shame Chrome into implementing it or something like that.
Well, and it's coming, right? We're seeing, and Apple is actually implementing far more do not track in their next generation. And some of the other companies are starting to as well. So, if we're successful with Privacy Badger, the world won't need Privacy Badger anymore because it'll be built in. Yeah.
Yeah, that is a really cool thing. Now, one of the things that intrigues me about EFF is you are certainly not a single issue organization. Mm-hmm. You navigate a pretty complex legal and I'd even say moral landscape because there are multiple objectives that you're pursuing. Mm-hmm. And not just the three things in your tagline, although those are biggies. It would seem that in this complicated landscape, sometimes it's almost inevitable. Certain principles that you hold dear are going to come into conflict to each other. At least that seems to be the case to me, looking as an outsider. And I thought it'd be interesting to talk about a couple cases where two principles might, at least, again, to an outsider, appear to conflict, mm-hmm. and get a sense of how you think those through. Mm-hmm. So the first thing I'd like to talk about is the so-called right to be forgotten, mm-hmm. which probably many, but not quite all listeners might know about. It basically started bubbling up in Europe, I want to say probably almost 10 years ago. The mm-hmm. first idea came out, but I think it was in 2014 or thereabouts that some very high European court ruled that the right to be forgotten is a human right, in a sense, and basically has obliged search engines, notably Google, but I'm sure others as well, to create a mechanism whereby a person who believes that a non-Google site out there is in some way misrepresenting them can petition to have that site removed from the Google search results. And so it's always seemed a little odd to me that, like, why don't you go after the site that you think is misrepresenting you rather than the search engine? But in any event, that's what it is. And so when you read the coverage of Right to be Forgotten, it's often noted that privacy advocates were delighted and free speech advocates were mortified. You are both. And there are, I think, some very well-regarded privacy advocates. I mean, one that I tracked down that's said a fair amount about it is an organization called Consumer Watchdog, which seems to be a fairly progressive organization. I think its roots were with somebody who used to do stuff with Ralph Nader, et cetera. Being both a privacy and a free speech zealot, mm-hmm. how do you navigate this issue?
Well, I mean, we do have some sympathy for people who have false information about them out there and how hard it can be to try to track it down. But at the end of the day, the problem with these kinds of schemes is that there is somebody who's in charge of what other people can know, right? The right to be forgotten, that means that you have the right to get into other people's heads and have them not know something that they know again. That's extremely powerful. And to the extent that search engines like Google are how we locate information, or Bing or the others, you're basically saying there's some information that we shouldn't let people have. That's really powerful. And I, ultimately am not convinced that the mechanisms that the European Court of Justice and now the European regulators are beginning to implement are sensitive enough to that power being misused.
So did you feel a twinge when the debate came up, or did you have moments of uncertainty? Because it was a slow motion debate that built over 7 or 8 years. Was there a time when you're like, ooh, this definitely seems privacy oriented and I'm empathetic? Or did you feel pretty strong conviction from the beginning as this issue started getting discussed that this just sounds like government overreach?
It's probably more the latter. And I think it's because of the long work that we've done around anonymous speech, and anonymous speakers, and also helping speakers all over the world. We have helped dissidents all over the world try to get their voice heard. And what we find is that any of these mechanisms get misused by the powerful against the not powerful. Mm-hmm. And if you look at the history of the right to be forgotten and you see what has been taken down, it's rich people who can access this.
Yeah. You have to have the time and the resources to fight it, I'm sure. Yeah.
And so you end up with people who, are rich playboys who have played around pretending to be Nazis at parties, being able to get that information off the web. Whereas other people who may have serious, claims of criminal behavior that weren't true or things that are getting in the way of getting a job, they don't end up having access to these tools. So I think that, and having known that going in. I guess I saw this as the train wreck that it is slowly becoming. And, it's just too dangerous to try to make Google the arbiter of what you and I get to see and what we don't get to see. We've helped people involved in the Israeli-Palestinian conflict where Palestinians want to talk about human rights abuses and they get accused of engaging in hate speech. In places like the Ukraine, the people who are, trying to fight so that their country doesn't get taken over all by Russia as opposed to just the Crimea, the Russians will come on and they will claim that the people who are pro-Ukrainian independence are Nazis. They're actually Nazis. Now, there are some pro-Ukrainian independence people who I think are Nazis, right?
There is a right fringe there.
On the other hand, most of them are not. But how do you expect Google or Facebook to know that,
to adjudicate that,
to figure that out
with omniscience? I mean, it sounds like one mistake in there. Yeah,
and everything is pointing towards them taking it down, take down the speech, and so it's going to be disaster after disaster of information that you and I think is important that ought to be available getting taken down because powerful forces will be able to pull those levers and weak forces will not.
It's funny you said something that gave me sort of a curious thought. You said, it's getting into our memories. And part of my mind was like, but that's just Google. And then I was like, well, wait a second. Google is part of the world's hippocampus at this point.
Yes.
I mean, it is absolutely a functional extension of all of our memories. Another issue, and I actually don't know if EFF, I looked online and I couldn't find any statements from you guys on this. So I don't actually know if this is something you guys were engaged in. But another issue where I found certain of my own values very much in conflict, and I think that there are values that are probably shared here, was the whole free basics program that Facebook launched in dozens of countries, including in India. And so just a quick background for those who don't know, Mark Zuckerberg went on the record some years ago saying that connectivity or being connected is a human right. And he came up with an effort which has gone through a couple of names now. It's called Free Basics, which is basically a text-only version of Facebook, plus a lot of other resources, jobs, health, news, information, weather, that kind of thing. And what they do is they make this package of lightweight text services freely available to people who have very little money in environments where, generally speaking, people are accessing the internet through feature phones rather than smartphones. And the idea is billions of people are not online currently, roughly 4 billion, a little bit less than that right now, are not currently online generally for economic reasons. And so let's make it free and available. Now, this kind of went off without a whole lot of controversy in a lot of countries, but it gathered a great deal of controversy in India. And the resistance against it was that this was a violation of net neutrality, which is an important concept that, again, I'm sure most folks are familiar with. But to give it a thumbnail description, it's that nobody's internet should be adulterated by a company or any other entity that says you can see this and not that.
Correct.
And clearly, if Facebook is creating a lightweight internet experience in India and elsewhere, that is crossing the line, at least conceptually, with net neutrality. So this is a conflict. I'm very pro net neutrality myself, certainly in the United States. But as a practical matter, there's probably tens, if not hundreds of millions of folks in India who might have gotten online quite soon, who are now going to age probably a lot of years before they get any internet connectivity at all. And I think that much as I personally am ardently in favor of net neutrality, I wonder if it's something of a luxury good, that if somebody's choice is between getting online with even a conceptually offensive form of the internet, are they better off to not be online at all? It seems like it conflicts with a couple of EFF values. I'd love to know how you think about this one.
Well, we were a little engaged with Facebook Basics in India, but honestly, it happened really quickly, and we weren't an active part in it. In general, this phenomenon is called zero rating,
right?
And we have published some blog posts about zero rating and our view on them. We're very skeptical of zero rating. We're not saying that it couldn't ever be done well. But Facebook certainly didn't do this well. I mean, eventually they got to something that was kind of halfway decent, but originally, the slogan in India is, a poor internet for poor people. Facebook's original proposal here was that Facebook would hand select what you got to see. and would pay off, at least temporarily, some of the ISPs to make this cheaper for people. But the danger here is that you really there are places in the world where people think the entire internet is Facebook. Right? They don't know that there's other information that's out there and available.
What is there another website? I'm joking. That was.
So I've heard this is true in Colombia, where they strike sweetheart deals with local ISPs. I'm not sure if it's true anymore, but it was a few years ago. And the local ISPs only offer Facebook for free, and you have to pay for everything else. I think Facebook realized early on that wouldn't be good enough, and so they handpicked a few websites that
like accompanying sites.
Yeah, but I think that there is a real concern there that we end up with a corporate internet and that we lose all the non-corporate internet because the only people who can play are the ones who pay them off. I actually think that the pressure here ought to be on governments, state, local, national, to make the internet more available to people. I'm very sympathetic that we want more people to be able to get online.
Yeah, it's a tough one.
But Facebook made a lot of claims about this, like that, if they got people online, then slowly, their pitch to these ISPs is if we let them get online for free after a few months, then they'll start paying.
So they were pitching it as an upsell story?
Well, that's how they pitched it to the ISPs.
That's what I mean. Yeah, so that does start sounding very disingenuous. I mean, it's a tough issue because a poor internet for a poor country. I mean, if the rival slogan was like, to hell with that, we're going to have no internet for a poor country. I don't know if I like that either. And then I worry about governments. There are many countries where the governments are a lot worse than Facebook.
It's true.
India may or may not be one of them, and it probably varies from state to state because there's so many municipalities in India. But maybe the right way for this is, Mark's got a great deal of money, and so do a lot of other people at Google and Microsoft and other places, where I do believe that there is a fervent belief in the need to connect the bottom billion and the bottom 4 billion to the internet. Maybe 4 or 5 of these fabulously wealthy people who, again, I do genuinely believe in this stuff, should get together and create a truly, utterly independent philanthropy that will do these things.
And that would be an interesting thing.
It'd be kind of amazing, wouldn't it?
It would be. Yeah. And I don't think it's out of reach.
Interesting. Well, hopefully to be continued. Another thing that I often wonder about myself and struggle with is what I'll call the dark side of anonymous speech. Now, EFF has been in places described as a free speech absolutist organization, which I think is a great phrase. And your website very correctly states that anonymity often saves lives. That's probably truer in dictatorships and places with more violent political or religious traditions than our own. Whereas here, where that's less true, and there's a more benign government than in some places, things like doxing and revenge porn and other egregious privacy violations are often enabled by the availability of anonymity.
Well, I guess I would push back on that a little bit. There's been some real research done now, not just anecdotage. And the real research indicates that there isn't actually a very good connection between anonymity and all of these bad things. Plenty of people who do these things are easily found or findable, or don't even care whether they're found or not. I think that the work that's been done so far, that's actual real science and scientific social analysis about this, shows that there isn't actually a connection between online anonymity and a lot of these bad things. It doesn't mean these bad things are good.
No.
But if you're going after anonymity as a way to get at doxing, you'd be much better off to go with the doxers and go with the revenge porn. It's not that hard to find, especially revenge porn. It's not at all difficult to do that kind of tracking. And I worry that trying to get at anonymity as a way to do this, you'll lose a lot of babies with that bathwater if you're going indirectly at these problems by trying to go through anonymity. What to me would be much, much better is to really take a deep look at a lot of the tools that we have to help people protect themselves, to help people find out who's done this kind of stuff. There's plenty of them. We developed the test for anonymous speech. The test for anonymous speech isn't that you always have complete anonymity. It's that there has to be a very high bar before your identity is revealed. I think that's the right way to go because, we live in a country that was founded by people who had to act anonymously.
Anonymous pamphleteers, I know.
And the Federalist Papers were
and
published
Publius and all of that stuff. Yeah.
I mean, and we're living in a time now where I think there is a more heightened awareness that the government can misuse its powers against people.
Yeah.
There's a lot more organizing going on, frankly, on both sides of the spectrum, where people are nervous about the government having access to the groups that you're involved in.
Now, speaking of tools, I'd like to talk briefly about Tor, which is something that I'm sure you guys have a great interest and a great history in. I'm interested in this in part because I'm going to just mention my book very briefly. This part of the podcast is meant to be wholly accessible to people who aren't reading the book. Mm-hmm. But there's a powerful privacy tool in the book as well. It's kind of Snapchat meets Tor. Mm-hmm. And what's always very fraught in thinking about these things is that they absolutely protect privacy and anonymity. They help people resist government intrusion. I have no question but that Tor has saved many, many lives in a lot of very, very brutal places, and saves them on a daily basis. But at the same time, they are used by people who really desecrate the rights of others, including terrorists and child pornographers and so forth. There's all kinds of negative stuff that happens on the dark web as well. How should societies trade off interests like national security and, protecting highly vulnerable people like children and other folks? Is there any tool that goes perhaps too far in enabling complete anonymity or a complete ability to evade the law, et cetera?
I don't think so. I should say I'm a member of the board of directors of Tor, so I am not disinterested here. But I don't think so. In fact, I'm much more interested in the kind of tools like the ones that Cisco built. For tracking people and identifying people and committing human rights abuses against them than tools like Tor, which are aimed at helping people protect themselves. First of all, we are living in a time when the government has more tools than ever before to be able to find us, locate us, and figure out what we're doing online. There's a law professor named Peter Swire who calls this the golden age of government surveillance, and I think he's exactly right. But the important part for these purposes is the Tor network, while it does give people a lot of anonymity, is not perfect. And the government has ways around it already.
And it's a government product too, right? That's something that very few people realize. It's a Navy product, isn't it?
It was built by the Navy originally. Yeah. It's now an independent nonprofit, but and because the government actually likes to be able to do its surveillance and running around the world trying to figure out who the bad guys are and not being tracked either. So you have to be careful. Again, there are always babies that get thrown out with bathwater.
There are.
So I don't think that any tool that exists right now gives people perfect anonymity, and the government has to work hard to get at you, but that's the right balance.
Right.
The government ought to be able to work hard. In terms of terrorists, there aren't any terrorist attacks that have been tied directly to Tor.
Is that right?
I'm not saying that it couldn't happen, but there aren't. Honestly, most of the terrorist attacks that you heard of, people met in person.
Yeah.
To plan. And so are we going to ban people meeting in person because they might have a conversation that the government can't overhear? I mean, maybe we've gone too far with this in-person meeting thing. It worries me sometimes that when it comes to the digital world, people are willing to accept propositions that if they were made in the real world, we would all see were, not workable.
Well, another entity or class of entity that sometimes violates our privacy is companies. And another thing that I'll just briefly reference the book, another tool that Flutter has in the book is this thing called a file spelled with a PH, because everything in Flutter is spelled with a PH, which is this vast information trove that the company's amassed on pretty much everybody, including a great deal of information that predated the company. But the scariest thing is what the company infers. It's an app that shows near omniscience for correlating data about somebody and then figuring out, why are they going to this place, for what purpose, who are they going to meet with, and so forth. And, I definitely play my science fiction card in depicting that. But we're also 4 years after that shocking headline that came out. I remember when these Cambridge researchers were able to determine that they could predict race, IQ, sexuality, substance use, political affiliations, and more based on Facebook likes.
Correct.
Now, that was 4 years ago. Big data has come a long way. Facebook knows a lot more about us than our likes. And one of the things that I think about and worry about is, with big data getting bigger and bigger and more refined and the analytic techniques getting better and better, we're probably getting very close to a point where Google, Facebook, even maybe companies like Uber are able to infer far more than we tell them. Perhaps even far more than they could learn if they were actually eavesdropping on our communications with one another. Having inferred that, one could argue, well, that's their intellectual product. They just learned things and made some educated guesses about who you are. So now that's their property and they can resell that. Are there any protections that we have against really good inferences being made about us from deep learning and smart data becoming private property that other people can buy and sell?
No, I think we have very little protection against that, especially information that we voluntarily give.
Like likes.
Yeah. Or, something in the terms of service that says we're going to track you or whatever. We have almost no real protections against that kind of monetization. In fact, it happens. I mean, that's what your credit score is. There are lots of other things where people are selling profiles of you or slices of you, maybe not without your name, but with enough information where somebody could reach out to you and try to make a proposition, a sale or something to you. So we don't have very many protections yet. And the law hasn't figured out how to deal with this problem, right? The law tends to look at what they call PII, personally identifiable information. And that has some very specific protections in statute. But if somebody can infer PII from all sorts of other things that aren't PII, which is one of the things that we know that this Cambridge study does, which is it can look at, lots of things, not including your name, and identify your name and your address right away, usually just by telling where you slept and where you worked.
Yeah.
Two tiny little pieces of data that are readily available.
Nobody sleeps and works in the place where I sleep and work.
Exactly.
Yeah.
So it's not much data that can be used to identify people. And the law has not figured out how to deal with this, these little shards that add up to something more important. And I think it's going to be one of the challenges of our time to try to figure that out, especially when the information is maybe publicly available.
And also when the information can be affixed on us when we're navigating physical space. And
Correct.
so another thing that were my own sort of personal EFF-like values, I too am very pro-innovation, but I'm also very pro-privacy. I sometimes wonder what happens when augmented reality gets to the point where, anybody in a physical space, whether it's a cafe or a bar or a restaurant, can, by the mere act of glancing at somebody, get facial identification and get access to an extravagant wealth of data that in some cases might even go beyond what they could easily access online. Well, an earlier episode, I interviewed the CEO of a company called Merritt, which is a fabulous AR company, and basically a somewhat dystopian circumstance that I described in the book, at the beginning of the book, he felt the capability was about 5 years out.
Yeah.
How do we deal with that?
I think we have to figure it out. I mean, I have ideas, but I think that as a society, we're going to have to figure out what's okay and what's not okay. And are there limits, right?
Yeah.
I mean, we have limits in our world right now, right? Your tax returns protected. When they get breached, people feel harmed and they're rightfully harmed. So it's not, but we have to give that information to the government. People collect that, it comes from various different pieces. So we as a society are going to have to decide, look, there's some information or information combining that we may not let people do. And then we're going to have to find a way to police that. The other way to go is to try to say, well, it's just all fair game and people can do whatever they want with this information. But I think we'll be the poorer as a society if that's the path that we go down. Yeah.
Well, for what it's worth, his solution to this was an intriguing one. I think the term he used was public by default. And so the way he views it is if you're in a space that you're sharing with other people and you're accessing any information, there should be some kind of indication of what it is that you are looking at to the others that are in that space with you.
I think it makes me nervous because I think it presumes a level of watching each other that people may not really be able to do in practice. But I do think you can't talk about individual transparency without talking about power and people who feel secure in their power and that they can't be taken out if people know things about them are often much more comfortable with this idea of general, individual transparency. I think it gets much, much harder to say to somebody who might be an illegal immigrant or to somebody who might have a condition, a medical condition, to somebody who might have something going on in their lives where they are at risk, that everything they look at with other people around has to be available to all the other people around.
Well, you have lavished me with time. I am extremely appreciative of your generosity. I appreciate all this, and we will talk again soon, I'm sure. Here's a quick message from Rob before Tom and I start our discussion of the interview. You are now deep into a long podcast, which means you're a focused listener. I'd therefore like to make a quick pitch for the audiobook version of my novel, After On. It's a truly amazing production, in part because it's not read by me, but by actual professionals from the realms of acting, comedy, and beyond. The part of NetGirl, a very opinionated blogger, is read by the inimitable Felicia Day, creator of the web series The Guild, performer on TV shows like Mystery Science Theater 3000 and Buffy the Vampire Slayer, and so much more. The many Amazon reviews that are woven into the storyline, and yes, you heard that correctly, are read by the lovely and talented John Hodgman, actor, author, comedian, podcaster, and, to go back a few years, portrayer of the PC in Apple's famous I'm a Mac, I'm a PC TV commercials. The voice of the New York Times in the audiobook is the co-host of this podcast, Tom Merritt. The voice of the San Francisco Chronicle is tech broadcast veteran Leo Laporte. And the voice of a mysterious second novel that is excerpted repeatedly in After On is Patrick Rothfuss, the brilliant fantasy writer behind The Name of the Wind and other wonderful books. Other great voices include those of YouTuber Jesse Cox, Broadway actress January Lavoie, and Sean Kennan, whose voice you may know from Family Guy, The Smurfs, and much more. I'll add that at over 22 recorded hours, it's a pretty good entertainment value. You can find it on Audible or wherever fine audiobooks are sold. Now, back to our podcast.
Rob and I will now discuss the interview and sometimes make specific reference to the novel After On, particularly pages 110 through 180, which are officially on today's roster. If you're not reading the book, you may suffer occasional side effects like confusion. But since you've gotten this far, you'll still probably enjoy the discussion, whereas if you're planning to read the novel, beware of spoilers. Let's start with the podcasting patent EFF invalidated. I do a lot of podcasts, Rob.
Yeah, and you may have been looking at debtor's prison over that patent if Cindy hadn't invalidated it for you.
Thank you, Cindy. They would have reinstated debtor's prison just for me. Thank goodness for Cindy Cohn. But back to your story. So far, there's been at least one mention of a diabolical patent in the novel in that NetGirl interview with Tony Jepsen. Colors on web pages, right?
Yep, and it'll come into play again later in the storyline. Now, the idea of patenting the use of colors on web pages is obviously comedic, but it's sadly not absurdist because patents that insult humanity's intelligence do exist, and it is a crippling fact of life in the tech industry. As an example, do you know Drew Curtis and his website FARC?
I have a long history with FARC.
Cool.
Yeah, they used to link to my oldest website, civilian.com.
And I'll bet that triggered tons of traffic.
It did.
The FARC effect was and remains a very, very powerful thing. Well, Drew gave a TED Talk about being sued by a company that held a patent on the distribution of press releases via email. And did you know about that? I don't know if you were aware of that.
I had forgotten about that. You're right. Yeah. That was crazy.
And by the way, his website never actually distributed press releases via email, but he got sued for it anyway, and he fought it off. But it almost killed his company, which is basically a mom and pop operation. I mean, killing his company would have basically amounted probably to bankrupting his entire family. And the reason it was so deadly, as he says in his TED Talk, the average patent troll defense costs $2 million and takes 18 months if you win. Now, the same troll that sued him also went after Yahoo, AOL, and a bunch of other huge companies, but Drew was the only person who had the guts and the principles to actually fight it. And most do not even giant companies, which is why this kind of extortion is happening on such an industrial scale.
Because a giant company, they look at it and they're like, we could throw some money at this and it goes away, saves us money in the long run.
It's a cost of doing business, and if you really want to be sort of conspiracy theory prone toward it, and I'm not, but you could also say that if you're a big company, having that cost in the system makes it harder for startups to come along and start chewing at your ankles because you can afford to make these people go away and startups cannot.
Certainly a pleasant side effect for them.
It is a side effect that they, I'm sure, believe they benefit from. So it's really left to people like Drew who probably don't have the resources to take an enormous risk and fight on principle to do anything about this. Now, Drew was sued by what's called a non-practicing entity. These are lowlifes who buy generally ridiculous patents and then terrorize people into paying up. And they're parasites who literally suck the lifeblood out of those people that you and I count on to create jobs and growth and innovation. So I personally literally think of these patent trolls as economic criminals. And they exist because a tiny minority of the generally awesome people who are patent inspectors, most of those people are brilliant, but a tiny fraction are stupid, lazy, or cynical enough to think you can invent something as obvious as colors on a web page or emailing press releases. And then these scumbags pour in and start suing people.
I'm sorry, Rob, but I have a patent on indignant rants. Oh. So I'm going to have to serve you now.
Damn it. I knew that was going to happen eventually. I just didn't think it would be you.
I hate those people. I mean, I don't know those people, but I hate that kind of person exists. People like Jepsen in your book.
People like Jepsen. He is evil. Now, if he starts trying to charm you around page 200, and believe me, he will, remember, he's a patent troll and therefore from the lowest circle of hell.
So is it safe to say you feel strongly about this, Rob?
Yes, this is a very common thing to be self-righteously indignant about in the tech industry. Enough so that my own self-righteousness, which I think I've just amply demonstrated, and that of my industry merits a bit of mockery.
Ooh, trademark on Merritt there, too.
Oh, gosh. Sorry. Deserves a bit of mockery, which my novel does supply. So to quote it, and this is not a spoiler, though it's a bit further into the book than we are now, cannibals and Bothists are less popular than patent trolls in Silicon Valley, sure, but by narrow enough margins that it reflects poorly on everyone.
This is one of my favorite lines. Speaking of people abusing the legal system to shut people up, there's not just patent abuse. There's the Digital Millennium Copyright Act. There's poor Mike Masnick trying to discuss the invention of email and getting sued for the trouble.
Yeah, and to come off as the table-pounding caricature that I kind of am on these issues, the Mike Masnick situation, which Cindy and I discussed, is another case of our legal system basically prostituting itself as a mechanism to privatize powers that only governments should barely have. I mean, in free countries, we only grant governments the power to silence people, and only in the very narrowest of circumstances, like advocating for violence or yelling fire in a crowded theater or whatever it is. But a slap lawsuit kind of lets anybody with the money to enlist the legal system to silence people on the subjects of their choice. You can't lock them up, but you can threaten them with bankruptcy. And you don't need to win. You don't even have to have a faintly legitimate argument. You can bankrupt somebody simply by attacking them and letting the fees mount. And the legal system is configured to enable this. So 99% of people cave in and shut up. And people like Mike Masnick and Drew Curtis, I'll say it again, are basically heroes for fighting a corrupt system that, you know, to go really conspiratorial, but I think this is an accurate statement, generations of sleazy lawyers have created and maintained to this day as legislators, as judges, as regulators, and of course, as attorneys for both sides. So that's what I think.
Well, this reminds me of a bit further down in the book, but I don't think it spoils any of the story elements coming. The term privatization of the law. In your talk with Cindy, you used that, and you'll use it a little farther down in the book.
Yeah, a lawyer who we'll soon meet in the book, who was also in the book in Year Zero, for those of you who have read it, says, quote, if someone signs the right documents, they can become almost as subjugated vis-a-vis their counterparty as individuals are in relation to the state. Now, she's saying this in relation to Flutter's EULA, or End User Licensing Agreement, those things we click on and commit to without reading several times a week. And NetGirl has already, at the point that we are in the book, NetGirl has already mentioned the insanity of Flutter's EULA. And another blogger who we're about to meet calls it the War and Peace of EULAs because it is so darn long. Now, a little further in the book, and I find this just hysterical, Jepsen quotes an actual study, it's the study I find hysterical, that simply reading all the privacy agreements on the websites that we hit would take the average person 1.5 months per year. So that is literally a significant part-time job. We become legally bound by those things. So that's why we need people like Cindy and organizations like EFF out there fighting for us.
Yeah. Another storyline element you and Cindy talk about was the augmented reality scene, which also you and Marone Gribbets discussed at length in our first episode.
Yes, indeed. And I kind of expected Cindy to like Marone's idea of public by default, as he called it, because EFF is so very, very strong on all privacy issues. And And I personally worry about augmented reality making it incredibly easy to strip away every veil of privacy that we have in public with a mere glance. But Cindy surprised me by being more concerned about the privacy of the person accessing the information than the privacy of the person whose information might get accessed. Now, both parties do deserve a measure of protection. So it's really, I guess it is hard to know where to draw the line, which makes it clear, how very complex these issues are. Even if you have a really clear set of guiding principles, as EFF does, it's not always obvious how you would parse a given issue.
Yeah, because a lot of times you're protecting one at the expense of the other. Makes it very complex. All right, but let's get back to Flutter. It's been implied that Flutter's augmented reality project may have a government angle to it. Dana is told she needs a Homeland Security permit just to touch the wingman glasses. Why would that be? Earlier in the book, Pugwash exhibits thinly veiled fear when Mitchell asks about what Flutter's doing with AR technology. And there have also been hints that Flutter has something to do with the NSA. Now, this isn't purely fiction, as the tech world does at times collaborate with the intelligence community. For instance, Cindy mentioned the Patriot Act.
Yeah, and that was passed, as I'm sure a lot of people know, in the wake of 9/11. It permitted the NSA to collect what's called metadata on all U.S. phone calls. Now, that doesn't mean recording the calls. It means who called who, when, how long the call was, etc., but not the actual content of the call. Now, if the government got suspicious about someone, it was then quite easy to subpoena deeper things like the recordings of calls and the contents of emails and search histories and so forth with a warrant. And that would happen from time to time, and I'm sure generally, or at least frequently, with very good reason. And if an warrant was issued, everyone, Google, Facebook, Skype, Yahoo, etc., would be very cooperative, as they are obliged by law. So things went really smoothly between the government and all these tech companies for several years. Then the Snowden leaks came out in 2013, and a program called Muscular, and it's always in the PowerPoint slides that Snowden leaked, it's always in all caps. So it's like, is that an acronym, Muscular? Like it's like a 20-word acronym. That came to light, and the NSA, unbeknownst to all these companies, was using Muscular to secretly track these huge troves of data that all these companies transmit over transatlantic cables. So outside of the U.S., the NSA can do more than they can do inside the U.S. And the tech companies were furious because they didn't know about this, and a lot of voters were too. So the Patriot Act powers were pruned. In December of 2015, it came into effect. The NSA lost its ability to collect metadata on U.S. phone calls without warrants. And EFF was, in fact, deeply involved in that, as Cindy noted in our interview. So that is an example of collaboration, you could call it, or just mere abatement of the law, if you look at it through another lens, between the tech companies and the NSA. But this reduction in governmental powers was very, very significant. Again, as Cindy said, the NSA does not like to lose. A bit of foreshadowing. This reduction in governmental powers that happened in December of 2015 will be quite significant in After On in the pages to come. So please keep it in mind.
Right. Keep an eye on those hints, folks. Here's another one. Another thing hinted at the story so far is that some dark arm of the U.S. government may have been an early investor in Flutter. So not just surveillance, but putting some money into it, perhaps gaining significant control over Flutter. The name Gray Oak Capital keeps popping up, and that psychotic redheaded character Beasley is cited as maybe having some kind of government role, whether he does or doesn't. The idea of the government investing in technology companies is not just fiction.
It is not. Now, I'll note that I'm not aware of the government having flat-out secret control of any startups, because it wouldn't be a secret if I knew about it. So who knows? But the CIA has been investing very actively in Silicon Valley for almost 20 years. It's through a group that's called InQtel. They're said to invest about $120 million a year in Silicon Valley startups. And at least 100 of their 300-ish investments have never been announced. So we really don't know who they've invested. We know some, but not all. And their website is well worth checking out because it's got some creepy features. First of all, this can't just be accidental. It features on the front page an image of the Golden Gate Bridge looming over what looks like the skylines of Seattle and Washington, D.C., which may be an interesting symbolic statement about where the real power lies in the present day. And then even better, if you go to the management team picture, everybody is depicted on it is literally faceless. They're these sort of caricature sketches with no facial features, so you can figure out the hair color that somebody has and the presence of or absence of glasses. and that's it. So I recommend everybody check out the InQtel website. It's fun.
Really, really, really are faceless investors.
They are faceless investors.
Wow.
Yes, indeed.
So just as we can privatize law, we can also privatize spying. Hooray.
Mm-hmm.
You and Cindy discussed something that some people are even more worried about than government surveillance, corporate intrusion.
Yeah, and as data gets bigger, the ability of companies to track and make freakishly accurate inferences about us, which then become their intellectual property to share and sell as they see fit. The inferences they make will continue to mushroom. And these are things that go way beyond what any intelligence service could have gotten on any of us just a couple decades ago. I mean, seriously, what Facebook knows about each of us, everyone we've ever met, everything we like and dislike, the things that we'll say publicly and privately on almost any subject, etc., goes way beyond what the FBI has ever had on anybody on its 10 most wanted list, right? And this information can be abused. I mean, who could forget that Uber basically told reporters a couple years ago who gave them unfavorable coverage that basically Uber said, we know where you live and we know everywhere you go. And when you spend the night away from home, we know exactly who you've spent it with and we can get any dirt we want on you. That was a scary threat because it was credible. And that was a couple years ago and the data just keeps getting bigger and bigger.
Now, of course, some and not to say that those aren't bad things, but there are even worse people out there. And these real bad guys are also going digital, which is where things like Tor become very complicated. Going back to our trade-off on privacy, Tor can keep people's communications on the internet secret, whether they're human rights dissidents or extremists who want to blow you up.
Yeah. And I have less conviction on this point than Cindy. She was obviously in her interview quite unequivocally supportive of Tor. And I understand where she's coming from on that point because she is, as she describes herself, a free speech absolutist. Now, she's correct also, as she said in the interview, that a lot of terrorist planning happens face to face. After she and I sat down, I actually dug into this further. And I'd recommend to anybody who's interested in this subject, Graham Wood's book, The Way of the Strangers, which documents how ISIS recruits people in Western countries. And Mr. Wood spent a great deal of time with people who left the movement, with people who have flirted with it and not gone out there, et cetera. And in fact, a great deal of stuff does go on face to face. And as Cindy pointed out, there has not yet been a documented incident of people who want to blow us up doing that through Tor. But much as I believe in privacy and protecting dissidents from evil governments, the stakes of these sorts of folks rises in proportion to the strength of their weapons. And in the near future, the strength of technologies like synthetic biology really concerns me.
Ah, yes, synthetic biology. It seems like it strays a bit from privacy, but I must know more next week, perhaps?
Yes. Next week, we will be talking to Autodesk distinguished scientist Andy Hessel, who is in some ways, in many ways, in fact, probably in the most meaningful ways, the catalyst behind what's called the GP Write program, which some have called the Heir to the Human Genome Project. We'll be discussing both the promise and the peril of synthetic biology. And a couple weeks after that, we'll be talking to Sam Harris, who is one of the most outspoken and controversial people in the country on the subject of nihilistic movements that want to blow us up. He's also had quite a bit to say on the subject of artificial intelligence risk. And you and I, at the end of that podcast, will be discussing pages 180 to 241 of the novel After On.
So that's not frightening at all, folks. Sleep well. We'll talk to you then.
We will indeed.